the Assembly Judiciary Committee for Tuesday, April 21st. We do not yet have enough members even to start as a subcommittee. Once we do, we'll start hearing bills as a subcommittee until we get a quorum, and then we can start taking motions and proceed with our business. So have a little patience until we gather members here. All right, good morning. We can start as a subcommittee until we get a quorum. I will note that item number 1, AB 52, has been pulled from the agenda today at the request of the author. So we will start with item number 5, AB 260. Ms. Lopez. Morning.
Good morning. Good morning, Chair and Chambers. I'm pleased to present to you AB 260, which held certain information in parenting youth case file initiation during the procedures. This bill ensures that parenting youth and give additional support to services are offered for parenting foster youth regardless of the placement setting youth lives in. It's important that California does not create a circle of youth entering the foster care system at birth. Therefore, we must try the best to keep families united and to provide a proper resource to support them. Here with me, I have two witnesses in support who will be giving testimony.
Thank you. Please.
Good morning, Mr. Chair and members. Kyle Sporleader with the California Youth Connection. We represent foster youth throughout the state, and our members are ages 14 through 24. Every year we go through our own internal process where we have our members brainstorm and identify the issues that are most salient to them in the foster care system. And as the population being served by said system, we find that we find out some of the most significant changes we need to see in the system come from our members' brainstorms. This year, having identified parenting foster youth as a subpopulation that needs extra support, we were heartened to see that our members identified this group, considering this is a much smaller group in the foster care population. Parenting foster youth face many of the same obstacles that general population foster youth face, but as parents and as sometimes teen parents, they are tasked with being responsible for another human being. With this bill, we would like to ensure that these parenting foster youth are held to the same standard as other parents, even other teen parents, because parenting foster youth have their entire lives in a case file that is available for anyone to see, anyone in the system to see. And sometimes that means that they are held to a different level of scrutiny than other parents. So if there is a past history of, say, AWOLing from placements or mental health diagnoses or different behavioral issues that may have been apparent earlier in that youth's case file or earlier in that youth's entrance into foster care, we don't necessarily think that that information should be used to evaluate their fitness as a parent later on. This is something of a theme that we've seen in the foster care system of past information, outdated or irrelevant information being used against foster youth. But we also think that we need to initiate a culture shift so that parenting foster youth are supported in the same way that we support any foster youth who has different goals, such as career goals, professional goals, higher education goals. We like to recognize that parenting and having a strong family should be just as worthwhile as a goal as any of those, especially since foster youth were taken out of their biological families, often because those family situations were not healthy, and so one of their most motivating factors are creating a good family for themselves and being a good parent. And I have with me Mahogany Graves, who is a member of our Sacramento chapter, who'd like to talk to you a little bit more about some of the obstacles that parenting foster youth face.
Good morning.
Good morning, everybody. I am Mahogany Graves. I'm with the Sacramento chapter. I'm the president, and I'm also working with the Foster Care Ombudsman's Office. I work around a lot of foster youth, and I get a lot of phone calls from parenting foster youth, and it is a really huge struggle for foster youth to care for their children, as well as worry as if the social worker will take their children from them, or if something from their past that's not relevant could be used against them to have their children taken from them. So it's something that's very important and something that should definitely be looked at. So foster youth with children should have a bright future, just like anyone else trying to raise their children. Thank you.
Thank you. Next witness, please.
Thank you, Mr. Sharon, and I'm asking you for your aye vote.
Thank you. Any other witnesses in support, please? Any witnesses in opposition? All right, seeing none, I'll bring it back to the committee. Questions? Comments? Mr. Wagner?
Yeah, I've got a small concern. Well, I've got a large concern with the bill. In fact, it's why I'm probably going to vote no. And I didn't really hear it addressed in the testimony. My concern is this. Typically, we ask our judges not to legislate from the bench. That's our job. And the flip side of that is I think they would have a right to ask us not to make what amount to specific findings in cases. We're, with this bill, I think, taking discretion away from the judges who themselves are required by the law to have the best interest of the child in mind when they make their decisions. And we're saying with a blanket series, with a blanket category of cases, that the judge shall find this particular result or outcome. And I'm not sure that we're in a position to be able to say that. The testimony tells me about how important this class of juveniles is, absolutely undisputed whatsoever. But help me get over that concern, because that's what's keeping me from voting for this bill, that we are intruding into the judicial function. The judge in the particular case is in much better position to evaluate than we are, as far removed as we are from the particular courthouses. And why is it right for us to say in every case the dependent shall not be declared to be at risk given the circumstances? Help me there, because that's my problem with the bill.
If I may respond. CYC actually definitely did think about that concern prior to introducing the bill with Assemblymember Lopez. And so we consulted with CWA representing the counties and CLC representing dependency attorneys, since they have obviously a clearer picture of how things work on the ground than necessarily some of our advocates. And in our latest set of amendments that occurred in the prior committee in Assembly Human Services, we worked with them to figure out some language so that we still allowed that kind of discretion, because it's kind of a balancing act, because we obviously want parenting foster youth to be held to an equal standard and not some unfair higher standard. But at the same time, we always want to ensure that children are safe, because if children need to be taken away from any parent, even if that parent's a foster youth, and enter in foster care, then we don't want to prevent that. We don't want to create barriers for that. And so if you look at the bill in print now, we put in some language to make sure that it's not this blanket, complete roadblock to the courts doing their due diligence. We're just saying that we would like them to take a closer look when it is a parenting foster youth, so that information from a youth's past isn't automatically entered into a case as evidence, but they absolutely still can look at that, and they can still use information from the past as evidence. There's nothing barring them from doing that, because we do want to ensure that the children are safe regardless.
Any other questions from the committee? I saw this in Assembly Human Services, and I think this does not take away judicial discretion if it is relevant to the case. The judge can certainly look at it and do what they need to do. The problem is that what they're trying to do is make sure that it's not being used unnecessarily without some establishment of relevance to that particular case and what's happening there. So I agree, and I think that the balance has been struck here, which is why I'm recommending a due pass, and I believe it's due pass to appropriations is what the motion is, although we don't have a quorum just yet, so we can't take a motion. Any other questions from committee members? All right, Ms. Lopez, you may close.
Yes, Mr. Chairman, I asking you for your aye vote.
All right, thank you.
Thank you.
Thank you.
So next we have, it looks like, item number 7, AB 459, Mr. Daly.
Thank you, Mr. Chair and committee members. AB 459 allows the owner of a life insurance policy to seek declaratory relief if there is a question of whether the original purchaser had a valid insurable interest in the life of the insured. In order to qualify for this relief, the policy must have been sold prior to 2010 and have a death benefit of at least $1 million. This bill is a result of negotiations between the Institutional Longevity Markets Association and the Association of California Life and Health Insurance Companies. It resolves ongoing disputes between life insurers and the investors who purchase life insurance policies issued before California laws regarding insurable interests were changed in 2010. With me in support of this is Annalee Patterson of the law firm of Orrick, Harrington, and Sutcliffe.
Thank you. Your witness, please.
Good morning. Mr. Chairman, members of the committee, my name again is Annalee Patterson. I'm a partner at Orrick, Harrington, and Sutcliffe, and I represent Fortress Investment Group, which is an asset management firm that manages investments on behalf of large institutional investors like public and private pension funds, universities, and charitable foundations. We, on behalf of our investors, did purchase about 1,400 life insurance policies from banks as part of a large portfolio. We are here today in support of Assembly Bill 459, which is a compromise that was reached after many months of discussions with the life insurance industry, and I'm happy to answer any questions that you have.
Thank you. Next, please.
Brad Wenger, representing the Association of California Life and Health Insurance Companies. We have worked with the sponsor since last summer, more recently with the author, and are comfortable with the language and do think that it will provide a path to resolve these disputes, and we would urge you to support it.
All right, thank you. We're going to pause briefly and establish a quorum.
Stone.
Here.
Wagner.
Here.
Alejo. Chow. Chu.
Here.
Gallagher. Here. Garcia. Here. Holden. Mainshine.
Here.
O'Donnell.
We do have a quorum. Thank you. We have a motion, and the motion is do pass, and a second. Thank you. Any other witnesses in support? Any witnesses in opposition? I see movement, but it's not clear. Nope. All right. So back to the committee. Questions, comments? All right. We do have a motion and a second. Mr. Daly, you may close.
I respectfully request an aye vote, Mr. Chair.
Thank you. All right. If you call the roll, please.
Stone.
Aye.
Stone. Aye. Wagner.
Aye.
Wagner. Aye. Alejo. Chow. Chu. Chu. Aye. Gallagher. Gallagher. Aye. Garcia. Garcia. Aye. Holden. Mainshine. Mainshine. Aye. O'Donnell. O'Donnell. Aye.
Thank you. Your bill is out.
Thank you, Mr. Chair and committee members.
Thank you. And I'll take a motion on the Lopez bill, item number 5, AB 260. Recommended motion is do pass as amended to appropriations. I'm sorry, do pass to appropriations. We have a motion and a second. Thank you. Call the roll, please.
Stone.
Aye.
Stone. Aye. Wagner.
Aye.
Wagner. Aye. Alejo. Chow. Chu.
Aye.
Chu. Aye. Gallagher. Gallagher. Aye. Garcia. Garcia. Aye. Holden. Mainshine. Mainshine. Aye. O'Donnell.
That bill is out. And I will take a motion on the consent agenda unless anyone would like to pull an item. Seeing none, we'll take the motion. It has been moved and seconded. Call the roll, please.
Stone.
Aye.
Stone. Aye. Wagner.
Aye.
Wagner. Aye. Alejo. Chow. Chu. Gallagher. Gallagher. Aye. Garcia. Garcia. Aye. Holden. Mainshine. Mainshine. Aye. O'Donnell.
All right, that still needs one more vote, so we'll put that on call. Mr. Mainshine, are you ready to present? We'll now move to item number 4, AB 193. All right, we will not move to item 4. We have a dearth of authors at this point. Mr. Gallagher. Yeah, okay.
Mr. Stone, my item is here. Unless you want to go with Mr.
Okay. We'll go with item number 4, AB 193. Mr. Mainshine. Go, go, go. Please, go ahead.
Thank you very much, Mr. Chair and committee members. Today I present AB 193. This bill would serve to get individuals with severe mental illness that are overlooked by current law the help and treatment they truly need through an LPS conservatorship. Under current law, only a professional from a county, agency, or facility providing intensive treatment or evaluation services may make a recommendation to the conservatorship investigator for an LPS conservatorship based on specific findings of an individual's level of disability. If an individual is not receiving such intensive treatment or evaluation services, no such recommendations can be made, and no LPS conservatorship may be contemplated. At the same time, the probate code governing traditional probate conservatorships only allows for treatment of a conservatee in a secured facility or involuntary administration of psychotropic medications when the conservatee has a diagnosis of dementia and not for any other mental health diagnosis, no matter how serious. This creates a gap in treatment availability into which fall individuals who are not already hospitalized and thus cannot be recommended, but whose problems stem from mental illness and thus cannot qualify for treatment under the probate code. Additionally, as my witnesses will explain in detail, the definition of dementia seems to be ever broadening to include a wide range of mental health signs and symptoms. This has led to family members and other interested parties who have been denied access to even the initial stages of LPS proceedings to pursue dementia powers in their existing probate conservatorships. These powers include far fewer protections for the conservatee and extend greater authority to the conservator. This leaves a greater potential for abuse where an LPS conservatorship could have been far more appropriate. AB 193 would simply allow a judge presiding over a probate conservatorship to recommend to the county investigating officer the establishment of an LPS conservatorship when there is evidence of grave disability as a result of a mental disorder and make associated procedural changes necessary to carry out this authority. As the committee analysis points out, this bill covers a seemingly narrow group of people, and they must meet the criteria for an LPS conservatorship before one is granted. Thank you for the time and opportunity to present this bill this morning, and I have some members of the Conference of California Bar Associations with me who will be testifying in support.
Thank you. Your witnesses in support, please.
Good morning. My name is Jack Osborne, and I am the president of the Bar Association from San Bernardino County, and I'm a practicing probate attorney. I'm in the trenches every day dealing with conservatorships, both on the probate side and also on the LPS side. And why this bill is important for us as practicing attorneys is it is an effective way to make sure that our clients' rights who are suffering from a mental disorder are protected. Right now in the probate court, the probate judge, as you'll find from one of the judges who's here today, has limited tools available to protect the rights of our clients. Our clients' rights are best protected on the LPS side. There they can get treatment. The conservatorship is only for a year with an evaluation, and there are lots of tools available on the LPS side to make sure that our clients' due process rights are protected. What we're finding now is that in the probate court, our clients either are not getting any sort of help, or the help that they're getting often is bootstrapped into perhaps a diagnosis of dementia, so that they are being treated for something that they don't have, and the conservatorship on the probate side can last for many, many years until it's terminated. So we think this is a really good tool that will make available to probate judges in the probate court the ability, when there does seem to be a need, simply for an evaluation to determine whether an LPS conservatorship is appropriate. So now I'm going to turn the microphone over to Honorable Michael Welch, who is our former presiding judge from San Bernardino County, who has handled both the probate court and the LPS court for many years.
Right. Judge Welch.
All right. Thank you, and good morning. First of all, let me tell you a little bit about myself. I am retired as San Bernardino County Superior Court judge. I was a commissioner for approximately 5 years and then a judge for 17 years. During my time on the bench in San Bernardino, I was the presiding judge also during that period of time. I served on the Judicial Council from 2006 to 2010. I also served on the Probate Mental Health Advisory Committee during that period of time. And the reason I did that is that I was the supervising judge of the probate department of San Bernardino County for 6 years. I served in that capacity. The last 6 years I was on the bench. My calendar as a probate judge consisted of not only probate matters but the LPS calendar, which we actually did 2 days a week, or 1.5 days of every week I did LPS matters. I might indicate to you an interesting statistic about probate calendars, and that's this. A probate calendar has with it a conservatorship component of approximately 25% of the caseload of a probate judge's calendar are in fact conservatorships. Yet we find that over 50% of the actual work, the judge man hours to do that calendar includes servicing those conservatorship cases. So even though it's only 25% of the caseload, 50% of our work is in conservatorships. And the reason that is that conservatorships are designed to function around one person, and that's the conservatee, and what his particular needs are why the case is in the courtroom. We get input from family members. If it's a competing petition for probate conservatorship, we'll get family members on both sides, so to speak. We get a court investigator's report. Generally speaking, there's always going to be an attorney that is appointed to represent the conservatee. We get input from the conservatee. We get access to capacity declarations, which is an essential part of the probate agenda or the conservatorship agenda. And we also get a great deal of additional medical information from the family and from the attorney. We know these cases well. We also, because of our experience in the mental health court, the LPS court, know that in some cases the probate conservatorship just won't work for these individuals. They need a different kind of care, and that is because they're suffering from a mental disorder as distinguished from a dementia or some other physical disorder which affects their capacity. So in those cases, that is why what I would see on the LPS calendar and how they are taken care of, how medical powers are granted to the conservatee with respect to administration of drugs, psychotropic drugs, how they can be placed in safe environments to protect themselves and to protect others in the community. So I know about that, and I would then, with this bill, have the opportunity to tell the probate or to tell the conservatorship investigator, that essential person in the process, to tell that person, look, you need to investigate this case. You need to find out, and with all the information I have, it leads me to believe that this might be a case that's properly an LPS case and not a probate conservatorship case. The probate conservatorship can only go so far. They can't carry it forward to do the involuntary treatment with respect to medications and or locked facilities absent of dementia finding. These cases, when I was on the probate calendar, would come to me and I would see them. I didn't have the power to do anything, but because I was the probate judge in San Bernardino County, what could I do? I could call the investigator, the conservatorship investigator, and might say, maybe you should look at this case. That's the only thing I could do. I couldn't do anything more than that. And if the conservatorship investigator wanted to accommodate a judge, he might do that. But probably he's not going to necessarily be compelled to do that. In this, if it were done as this particular code section or as this particular bill emphasizes, it would give that judge, the person that is keenly aware of the conservatee and what concerns him, it would give him the power to say, investigate this, conservatorship investigator. This man deserves, or this person deserves, quite possibly an LPS conservatorship. If it's done that way, then think of an additional feature, and that's this. If it's done that way and they get into it at an early process, think of the cost savings to law enforcement. Think of the fact that maybe that person isn't out there on the streets endangering himself and others, creating problems for medical issues for himself, maybe possibly other people, law enforcement issues that if a crime is committed would come into fruition, prosecution, and court time in yet a different court in the criminal courts. By getting early into the case based upon the probate judge's recommendation.
Judge, I do need you to wrap up.
Time. Okay.
Thank you. Next witness, please.
Pardon me?
My name's Karen Horsbull. I am a probate attorney in San Bernardino County, and I strongly support this bill.
Thank you. Other witnesses in support? Seeing none, witnesses in opposition?
Good morning, Mr. Chair and members. Trent Smith, representing the California Association of Public Conservators, Public Guardians, and Public Administrators, and we are opposed to the bill. We've had conversations with the author and many of you, and we admit that there are a lot of gaps in the mental health care system today, and we're all frustrated in trying to deal with those. Our clients, the public conservators, often, even under current law, are left dealing with a lot of these cases where the courts can't quite figure out what to do, and so often the judge will contact the public guardian and say, can you investigate and look into how we best treat this particular individual. Under this bill, as you've already heard, there are two distinct systems, the probate and the LPS system. The LPS system has a very high threshold because of the personal restrictions on someone's fundamental rights that eventually are taken under the LPS system, and therefore it has a very high trigger to begin an investigation like that. You have to have a medical professional determine that this person likely has a mental illness, and therefore the LPS investigation should begin. And that's because, again, you're talking about taking away someone's fundamental rights. Under this bill, you would allow a probate judge, and with all due respect to the judge who testified, who may see a lot of these cases, they are not a medical expert who are able to determine whether this person has a mental illness and should have that investigation begun. But in these cases now under this bill, when a judge who, again, doesn't know quite if this person qualifies for an LPS or otherwise, an investigation would be directed. Our clients would be the one most often who would do the investigation. They would have 30 days to complete that investigation, which we think is a very difficult timeline when, again, making some very fundamental decisions. And under the current law and the current system, our clients don't have the resources to do the job that they're asked to do right now. And so we think this bill is only going to compound that problem by having more and more investigations. And we still think it is appropriate that these investigations for a system which are going to severely restrict someone's rights be triggered by a medical professional and not a judge. And again, the judge who testified, who's seen a lot of these cases, I have no doubt that he has been frustrated with those cases, but I would just point out that if this is a system that's supposed to make it easier for the judges, as far as I know, aren't supporting the bill and aren't certainly the sponsors of the bill. So again, we are happy to deal with the author, the committee on a lot of these gaps that we personally see because, by the way, I'll just conclude, even if more and more of these people go through the investigation and we conclude that they are in need of an LPS conservatorship, in most counties we won't have a place to put them. There are not enough mental health facilities to put all of these people. So that's a major fundamental flaw in the overall system, and this is just going to exacerbate that. So again, we remain opposed. Thank you.